Hey everybody, welcome back to another edition of the Shoe and Show. It's always good to see you and to have folks who are engaging with us actually around the globe. We've gone to video this year, which has helped even spread this content even further. And so I encourage you to download the podcast where you get your podcasts, or subscribe and like us on YouTube at shoetube.org. Today, Thomas, you and I are going to talk about the one thing we've been talking about a lot with our members, and that is the potential for refunds. And so what do we mean by that? Is it a refund because your shoes don't fit? We take it back to a rack room? No, it's not that. It is the potential for billions, if not trillions of dollars to be refunded.
If you weren't watching video, Matt, you got to go back and watch the video because Matt did a little a reference there.
That's right.
That was pretty good.
Which will age us, but
trillions of dollars.
Trillions of dollars. So Thomas, what am I talking about? And let's kind of hash it out so that our viewers understand what's at stake and then what the potential is, and maybe a few buzzkills along the way.
Yeah. So there is a very big tariff case that is now going all the way to the U.S. Supreme Court. The IEEPA tariffs, the International Emergency Economic Powers Act. This is what President Trump used to impose the reciprocal tariffs. He negotiated all these several deals with countries, and with the threat of reciprocal rates under this broad, powerful tool that he has. That's been challenged. He's also imposed other tariffs, like the fentanyl-related tariffs on Mexico, Canada, and China under this same tool. And now there's challenge to that. The lower courts have said the action was illegal, that it was beyond the scope of his authority to impose the tariffs. And the Supreme Court has agreed to hear the case in early November. The very first week of November will be oral arguments. There are going to be briefs that are filed before that. And then we're going to get a decision on it soon after that, or at least, maybe beginning of 2026.
I mean, I've even seen December of this year, right? So it no matter whatever it is, December or January, it's going to be expedited for sure.
And the stakes could not be higher. We were talking about billions of dollars that U.S. companies have paid to the U.S. government that could potentially, there are all these different scenarios that could happen under this. One of them would be the court says the refunds have to be paid. The government, you can imagine the chaos that will happen if that is the scenario where the government has to figure out a way to pay back all of the money that it's collected from U.S. companies, from the importers. And so that is one scenario, and we can get into that. Like, what should you be thinking about now if that happens? But not to get everybody too excited, another scenario would be the court affirms presidential power and says, you know what, President Trump does have this authority. He can do this. This is within the scope of the executive branch. And the tariffs at that point are here to stay. And, he can continue to use this tool in other areas. And then there's many things that can happen in between. There's also the scenario that even in any of those events that we just described, the president can move on to one of the many other tariff tools that he has in the toolbox. We can mention those as well, but there are several other avenues that he could go down if he wants more tariffs.
Yeah. So before we kind of nerd out with different section numbers, Thomas, that we've all have been blazoned in our brains at this point, let's kind of unpack a little bit more of the historic nature of this, because of the fact that it is billions of dollars. And really, there hasn't been a president in our history that's utilized such a broad-based, broad-stroke tariff approach to try to get us back to 1930, right? If you wind the clocks back and you look at history, we had relatively low tariffs heading into the Great Depression, and during that time, in an effort to really protect domestic industry, which, I think on paper might feel good. It might feel good. Let's put up some barriers so that we can protect our domestic production in a time of economic strain, had the exact opposite effect. If you talk to most economists, and this has been broad-based kind of understanding of history and economics for generations at this point, but the Smoot-Hawley Tariff Act of 1930 actually made the Great Depression even worse. because it created these barriers. It took down the ability for our companies to compete. We don't have competition. You maybe don't even produce as efficiently as you should. And the other point is that once you start putting up barriers, countries with whom you've used to trade will put up their own barriers. So your product becomes more expensive to export to those countries. You can't even get into their markets, and everything kind of spirals out of control. And so over time, then World War II sets in, and these are broad brush strokes. World War II sets in. Clearly, the military-industrial complex drove our growth out of the Great Depression. And then in the post-World War II era, as we established these institutions to govern us and to help with global trade and things like the World Trade Organization, things like NATO, to help govern conflict and those types of things, they've been in place since you and I hit the scene and even since. And so the president came with a different perspective, that this notion that the average duty rate of 1.5% on U.S. imported goods is not good for our economy because it means domestic production has gone away. So President Trump arrives on the scene with a different perspective relative to trade, and the thought being that a 1.5% average import duty on U.S. imported goods is not good for domestic production. And so he is, I think, Thomas, been trying to get us back to those levels from 1930, kind of ignoring conventional wisdom, ignoring the so-called experts with this gut that, these countries have free access to the world's greatest market. We shouldn't provide that. And ignoring that at the end of the day, it's Americans who pay these duties for the access to these products. So there's a lot to unpack there. But the point being is we're now in this era where we're having exorbitant high rates. I mean, just to give you an example, we typically pay as an industry about $3 billion in duties every year. We're going to pay about $5 billion this year, which is a massive increase. That all is going to flow to the consumer. But it comes down to this court case and seeking these refunds.
So we do one or two thinking about this broadly, how the case impacts the timing, right? So the administration is going down this one path with this tariff tool, and you get these statements also that this is going to be, it's very hyperbolic. This is going to be, as Peter Navarro said, the quote, end of the United States. If the government loses here, the stakes are that high. And then you have Treasury Secretary Bessent making comments about this could end up paying back $1 trillion. We haven't collected that much, but the government hasn't. But suddenly this is, trillions of dollars are at stake here into the United States. The president said, I guess we'll have to unwind all the deals we've done. So really painting this doomsday scenario if this does happen, if the Supreme Court rules against the administration. And meanwhile, the administration is also preparing Plan B, to where it would come in and use one of these other tariff authorities. I just wonder, going into 2026, just with the midterms, with everything else, with the economy, how this all plays out if, in fact, the Supreme Court were to issue the refunds. Would the administration at that point, even, I know it's saying right now it would unwind all these deals. Does that actually happen, or potentially unwind the deals? Does that happen? Does the administration choose a new tariff tool? And there are several different ones that it could choose to use.
Yeah, it's setting the hyperbole aside, we know the United States won't end because the president can't apply tariffs under IEEPA. Again, this gets to the heart of the matter. Even the court has said you haven't really proven an emergency, which is what IEEPA is for. So the thought that the court's saying it's not an emergency, the American people saying there's not an emergency, the president thinks there's an emergency. Obviously, Peter Navarro does. So I guess the logical extension of that is if you take this away, by golly, this country's screwed. But setting that aside, the Treasury Secretary said, hey, look, if we have to do the refunds, we got to do it. I mean, that's if the court says it, we got to do it. And so I look at kind of the president and his team, and it's not surprising, and it's understandable. They want leverage. I've worked in administration. Every administration wants trade leverage going into negotiations. And USTR has been, for generations, very protective of not giving away tariffs without something in return. They're negotiators by trade. That's what they do. And so you come in with a chief negotiator, and the president himself clearly views himself as that, and that's his background in real estate. he's going to want to create maximum leverage. And so that's why in his mind, he says, we're going to have to unwind these deals because I'm losing leverage. And he's not wrong. I mean, some of the big countries are probably thinking to themselves, why do I even need to be at the table right now if this is going to be struck? Why not just kind of, rope a dope, hang out for a while? Maybe we meet technically, but don't agree to anything until we see what the Supreme Court does. While other countries, particularly in Southeast Asia, that need the U.S. market, they're hungry for an economic alliance with the United States, vis-a-vis one with China, are, I think, still at the table, and they're going to still be talking. And we're encouraging our trading partners to still be at the table. Like this will work its way out. But to your point, Thomas, the administration will move to something else. They've already indicated they will if in public settings within the media that they'll move these other sections. They're very obscure to the common viewer. But there's one in particular, we won't go through all of them, but 338, that's the one that we keep hearing it will be used, that has a cap of 50%, but it's all around discrimination. If the president deems that a country is discriminating against the United States, he has the authority to implement a 50% tariff or even stop imports from that country from coming in. And so there's a lot of power within that, maybe not as broad-based as IEEPA, but that's just one example. Like, this isn't over. Even if we do win this case and refunds are granted, they will continue to look for ways to create leverage to negotiate these agreements.
And you've seen that happened in even the last administration. The court would rule that something was beyond the authority, and that's true. Presidents do try to expand the bounds of executive power, what they can do. Obviously, not to this level as we're seeing under the current administration, but I think what happens if the case it goes against, if the president loses at the Supreme Court, what they would do is go back to the drawing board, and they already have the plans ready. They would probably say, to your point, let's go to the next most powerful tool, which is 338. Let's start using that as leverage, and then that'll get challenged. There'll be lawsuits over that, and then I'll give you one more. There's Section 121, which it's limited to 15% added tariffs, and Congress has to come in after 150 days and say, okay, we'll vote to approve this. So that would be another one that the administration could also use. Again, you're running it unclear what the makeup of Congress looks like. Will the Democrats take back the House and take the Senate? If that happens, then obviously that tool becomes very limited, not an option. But right now, it is an option. And so I think we'll see the same pattern. We'll see the trade agreements, or really tariff negotiations, not trade negotiations. And we'll see these tools used as leverage. But I think it's more of an economic calculation and a political calculation. After the Supreme Court makes its ruling, the administration has to decide politically, does it make sense to continue the tariffs? Economically, with everything that's happened to the economy, does it make sense to continue? Or could the president, is there an out? Could the president say, that they have negotiated some deals and tout the benefits that the administration sees in those and move on?
Yeah, no, it's a good question. The other thing is inflation's out there. We just got the CPI reading a couple of weeks ago around overall inflation, 2.9%, higher than what the Fed would like. Footwear was up there as well, pushing nearly 2% in increased costs. Women's shoes were up, highest they've been in almost 3 years. So we're starting to see the tariffs kind of make their way through the American economy. But Thomas, as we close out, what are some things that we're encouraging our members to do as they think through the possibility of tariffs? While it's not a foregone conclusion, and don't literally take it to the bank, what are some things that our members can do or footwear companies can do in preparation?
I think, two things that are important. I think one is record keeping, making sure you're keeping documentation of everything that's happening right now. Well, this case is expedited, so we'll know fairly soon what's going to happen. But I think making sure that you've got the documentation now. The second would be staying connected. We are constantly sending out tariff alert emails. We are connecting every single week for our members every Tuesday at 2 p.m. Eastern time. And we talk about these issues. We give you real-time updates. So it is a very fast-moving situation with the Supreme Court. We want to be sure you have the most relevant information, the best analysis, intel, and timely information. So I would encourage you to tune in to those weekly calls and discuss this issue with us there.
All right, folks. This is a to be continued conversation. We'll hear more as we head into the oral arguments. We'll do a breakdown. They release the audio of the oral arguments, and we will kind of pick through how each of the justices approach the questioning and whether they seem cynical or supportive. It's not always a determining factor of how they'll rule, but it was an intriguing way to continue to splice and dice the case. Go to fdra.org for tons of information. If you're not a member, we're tracking this hourly, and our members know it, and they're getting the information they need in a highly uncertain time. So check that out. And until next time, Shoe and Show is out.
Shoe In has been brought to you by the FDRA, the Footwear Industries Association focused on retail, trade, politics, and fashion, helping create and enhance conversations on all things footwear. For information about FDRA, visit fdra.org.